Our product has been always considered the pace setter in our industry, and it really goes right back to when a customer said, we need X in the software. We took it very seriously. I don't think I knew any better. I think if a customer in the early days said, oh, my software has to do A, B, and C, by the time I got back to the office, if I was on a sales call, the developers already knew we needed to have A, B, and C in there tomorrow. So that's going on for many years and thousands of times, you end up with a great piece of software and a good reputation, I think. So listening to the customers is very cliche, but the reality is if you don't, you're not going anywhere. Really, the customers are smarter than we are in many cases, and it's hearing little things that they say and linking them together that is how we develop the solution. I don't know that we invented anything from base principles. So we knit together the fabric of all our solutions.
Protecting and owning a unique idea has been essential to businesses since the inception of the US Patent Office during the Industrial Age. Consider that Alexander Graham Bell filed his telephone patent just 2 hours before a Chicago electrician filed for a similar patent. Today, the labyrinth of patent laws and application processes is exponentially more complex. The current pending patent averages 31 months backlog of pending patents. Scott Weingartner is an intellectual property attorney with New York-based White & Case.
What's been interesting as we've entered the knowledge age is that the number of companies that have realized the assets that they have could be protected by various sorts of intellectual property, among which are patents, has really increased. And the types of property that can be protected has broadened as well. So for example, in the late 80s, early 90s, there had been disputes about whether or not you could protect software. People were all over the map on that issue. Now in this country, it's more or less of a foregone conclusion. And so you see the likes of Microsoft, IBM, and others filing huge numbers of patents in those areas. Financial methods, business methods too, later in the 90s also became the subject of patent protection. The courts settled a dispute in that area, and as a result of that, and the fact that that decision from the courts occurred in the late 90s during the dot-com boom, coincided to create this real huge number of patent applications that were filed, which in turn caused a sort of a wider awareness among companies of the sorts of things that they could protect. Intellectual property has about 4 major headings. One of the ones, as you say, that comes to mind first is expressive content. Writings, music, films, classic examples of copyrightly intellectual property. In addition, trademarks and trade names are a very widely occurring, well-known form of intellectual property. Brand names such as Coca-Cola and Pepsi are a classic example of intellectual property in the form of trademark, and some of the most valuable forms of intellectual property around. A third type is patent protection. Patent protection protects functional innovation. Trademarks protect source of origin type information, and copyright protect expression. The last sort of intellectual property, the last major heading, is trade secret information, which is valuable information that is kept secret, as the name suggests, which can include know-how, can include secret formulas, can include software. Any number of things falls within that last bucket.
We asked Weingartner to comment on working with a patent or intellectual property attorney.
Most patent attorneys are so used to being in an area that is rife with jargon that they really have to go around, get on the sort of lawyer hustings and talk to their client and get the technical people involved up to speed with what things mean. You really have to sort of preach the gospel to a certain extent of patent law, if I could use a phrase like that, because otherwise you just simply don't get people making the effort, because it does take a lot of effort to get ideas down on paper clearly. People are so busy, they're under the gun. There needs to be incentives that the company can create to draw people out of their cubicles, so to speak, or their offices, to get their ideas down on paper and to have them follow through. It can take many years, and it can go into litigation, in which case the inventors are going to be critical. There'll be witnesses in the case. So So this idea of having people that can come in and convey those ideas and get some enthusiasm is something that I would look for